everyone, welcome to HOA Fight Club. I'm Raylene Schifano. So today I would like to talk to you about a Bill of Rights for homeowners. Most states, or I don't know if I know of any state that has an actual Bill of Rights for homeowners in HOA and condo associations. So there's lots of things that you want to put in a Bill of Rights, but I had to go back and because I've never even seen a Bill of Rights, I had to find somebody that actually had written a Bill of Rights. In doing the research for this, I found the AARP has done a Bill of Rights for homeowners. So I took their outline and of course put my opinions in there. And then this is what I would like to introduce as a Bill of Rights for Washington state residents. And I know that there's a lot of states that could also use the same outline. So if you haven't talked to your legislators, I suggest you do. You can use this outline. This is from the AARP. It is not my outline. These are my opinions on here because, of course, I want what's best for the people. So I'm very attached to any opinion that would hold everybody responsible for their actions, not just the homeowners. So I'm going to share my screen with you because I think that it's important for you guys to see this in writing and be able to determine what your state could use, or if you feel that I'm not understanding why, maybe people think that they shouldn't have homeowners rights. So if you have that opinion that homeowners shouldn't have a Bill of Rights, I would love to know your opinions of why you feel that way. I know that there's many people that fight against the fact of these Bill of Rights, and we'll see what happens with Washington state in the near future, because this is what I'm introducing. So let's go, let's get into it. Let's share my screen here and perfect and share. All right, so here is my screen. So the right to security against foreclosure. An association shall not foreclose against a homeowner except for significant unpaid assessments, and any such foreclosure shall require judicial review to ensure fairness. So many people get foreclosed on for fines. You should never be foreclosed on for a fine that didn't have due process and the right to an attorney and all of that kind of stuff. Nobody should lose their home for a $50 fine that is caused by another neighbor disagreeing with them. Anybody else that has a conflict with their neighbors, they have to go to court to take care of it, small claims court or whatever, to prove their damages. I believe that the association should have to do that too. There is no due process in HOA. This violates the Washington Constitution, and because they've given the power of the municipality to a corporation and gives them the special privileges to fine and foreclose. So that is one thing that I think that homeowners deserve, is the right to security against foreclosure. The right to dissolve disputes without litigation. Now, the first thing that boards do if they don't agree with a homeowner or homeowner is questioning them is go to an attorney. The process of the CC&R is actually to spell out what the board is supposed to do if there's conflict. The attorney should be their last resort. Corporations, I know big corporations use attorneys all the time, but this isn't big corporations. This is just an association that is bringing money of the people together and making the improvements and paying the insurance and that kind of stuff. These should, if we're not going to consider these normal corporations in the corporation world, then they shouldn't have that privilege either to be above the laws. We're just giving them every kind of protection, but we're not really giving the association protection because we're not protecting the people. The members are the association. So we need some place where we can have mediation without it being one-sided. The Attorney General's office should be in charge of that. There should be somebody that can look at a CC&R and say, yeah, you're right, the board is in violation of this. It's really not that complicated. But instead, if a board's in violation of something, they go to an attorney, the attorney defends them. The attorney spends whatever money the board has, because they know that it's an unlimited fund, that the board can just charge special assessments to pay for the attorneys. And that is wrong. That's not how our assessments are supposed to be used. They're not supposed to be used against us. They're supposed to be used to restore, repair, maintain, and pay for the insurance. That is what they're supposed to do. The right to fairness in litigation. Where there is litigation between an association and a homeowner, and the homeowner prevails, the association shall pay attorney fees to a reasonable level. What's reasonable? I mean, really, what's reasonable? You're defending your home. What is reasonable to defend your home? The association doesn't have to justify their attorney fees, but the homeowner has to justify theirs. That is not fair and equal justice. And we need to do something about that. Litigation, first of all, condo associations shouldn't be in disrepair. I have never read a condo association declaration or bylaws that states that the association can allow any disrepair. Every time it says repair, restore, maintain. So if an association is in disrepair, that board is in violation of their duties, and their reasonable duties and their fiduciary duties if they have it in a state. Washington state doesn't require them to have a fiduciary duty. So there's so many things wrong with the laws that don't actually protect the homeowners. We should be protecting the homeowners, not the attorneys, property managers, and every other person that is making money off of the homeowners. That is why we have so many in foreclosure. That is why we're having such issues. My nonprofit would not be needed if everything was working the right way. So, because nobody's actually defending the homeowners. All right, we're going to go down farther here. And see if I can get my computer to work for me, and it's not doing it. So let's go here. There we go. All right, the right to be told of all rules and charges. So the homeowners aren't even getting the information. Boards seem to think that they can have meetings and do everything without the homeowners knowing. It happens a lot. A lot of people do not know what's going on there in their associations, and they're just fined before they know anything. Homeowners should be told before buying of the association's broad powers, and the association may not exercise any power not clearly disclosed to the homeowner if the power unreasonably interferes with homeownership. When you do something wrong as a homeowner, the board is the first person to fine you and bring you into compliance. But when the association board isn't doing what they're supposed to do, who brings them into compliance? No one. We can't even get the attorneys to fairly and objectively look at the thing because they want to take it to court because that's how they make money. So I think that everybody should be allowed in every meeting. I don't think there should be executive meetings in HOA. First of all, we are all equal owners. We should all know when somebody is past due. We should all know when an attorney is being hired. We should all know when there's litigation and who we're litigating against, because we are all responsible for those things. There should be no executive meetings. Attorneys should not be showing up and telling people, telling boards how to find people into foreclosure. It's just not fair. So that is my opinion, but I just think that we should have full disclosure, full transparency in HOA. These are corporations. They should not be able to hide what they're doing under the guise of its executive meetings. They should not be able to meet and make any decision without the homeowners knowing. They should have to email us in every email. You know, if you want us to follow these rules, let's all follow these rules. But CC&Rs aren't fair. They're all written differently, and they're written to protect the association board. They're really not even written to protect the homeowner if you read them that way. But if you read them fairly, they actually hold the boards accountable, but there's nobody in the law in the states that are holding them responsible for their wrongdoings. All right, the right to stability in rule and charges. Oh, what, we just did that one. Oh no, the right to stability. Homeowners have the rights to vote to create, amend, and terminate deed restrictions and other important documents. Where an association's directors have power to change operating rules, a homeowner shall have a notice and opportunity by majority of vote to override new rules and charges. In Washington state, you need 51% of the ownership present or by proxy to deny a budget. Okay, so they should need 51% to raise the dues, to raise the budget. They shouldn't need 51% to deny it. A budget should not be automatically approved just because nobody showed up. If people are not showing up, there's an issue, and that association isn't being ran as it's required to be ran. There should be quorums at every annual meeting. People should be required to attend this annual meeting. It is the most important meeting, and it should be the budget and the voting of the board. And everybody should be responsible for being there, just as you're responsible for following the rules and regulations of the declaration. Let's make that required. You have to show up at the annual meeting every year. require that by law. I bet you get a lot of people participating, and then people will understand what's going on in these associations. All right, going back down, my computer still is doing crazy things for me today. So I'm going to scroll on down again. All right, so the right to individual autonomy. Homeowners shall not surrender any essential rights of individual autonomy because they live in a common interest community. Homeowners shall have the right to peaceful advocacy during elections and other votes, as well as use of common areas. So if you're running for the board, every year there's an election. Every year on the same date or around the same date, every year there's an annual election. Usually there's 2 to 3 positions in a board that's open every year. So you need to make sure that you know when those elections are being held and how, and be able to run for the board, be able to hang signs or give out your information of why you want to be on the board, just as the board has the right. We should know our neighbors. You should have the email list or the homeowners' addresses so that you can send them letters, send them emails. You should all be involved together. You're in this together. So make sure they do that. The right to oversight of an association's directors. Homeowners shall have a reasonable access to records and meetings, as well as specified abilities to call special meetings to obtain oversight of elections and other votes and to recall order or directors. The biggest thing I have for my helping is people can't get the records of the association. The boards are denying those records. How can homeowners hold boards accountable if they're not able to access the records that required by law they're supposed to have? So if boards are violating the CC&Rs and are hiding records from us, they should be forced to step down, not defended by the association attorney. The association attorney should take those records and they should turn them over as soon as possible, within 10 days. If that attorney doesn't do that, he or she should be in violation of their ethics. That is unethical. You are violating the law. I have never seen a declaration or a bylaws that says that you can't have the records of the association. Why would anybody need to keep this stuff private? We are all equal owners. We have the right to know. Why do people think that we shouldn't know what is going on in our associations? How is that what's best for the all of the owners? We have the right to know everything. We have the right to vote. We have the right to run for office fairly. If we as a nation don't allow fair elections, how do we even require it in HOA? HOA is where everybody lives. We lose our homes if the homeowner is wrong. The association doesn't lose anything if they're wrong. The board doesn't lose anything if they're wrong. The attorneys don't lose anything if they're wrong. The property managers don't lose anything if they're wrong. What happened to fair and equal? We should have the right to have reasonable associations and directors. Associations and their directors and agents shall act reasonably in exercising their power over homeowners. I have seen that power corrupts. Power is corrupting many, many people, and it causes them to do things that they wouldn't normally do. In this case, in HOA, it becomes a fine and foreclose method. Fine them as much as you can, make money off it, make a percentage off the fines and fees that you're charging, charge them for attorney fees. I mean, the attorneys are making on an average, probably $3,000 a person that they're having conflict with at the minimum. So those attorneys are making a huge amount of money, and we should be able to hold them responsible. All professional agents shall represent the corporation, not the board. I want all property managers, community managers to be licensed, to be background checked, and to be bonded. I think that that is the least that our state could do to protect the homeowners. For these people are in our yards, they're in our houses, and they're not licensed by the state, and they don't have to have any sort of training. Anybody can be an HOA community manager, and it is costing homeowners a lot of money to have these people in our homes every month. They're in our They get to see all the secret documents the executive documents that they have. They're making the decisions for us, and it isn't appropriate. Professional agents should have to report rogue boards. If there's a board that's not following the CC&Rs and a homeowner points that out to an attorney or a property manager and they don't act appropriately, that attorney or property manager should lose their license. Any attorney that takes CC&Rs and understands that records should be turned over yet denies those records, those attorneys should be fined and they should go into foreclosure for their ethics. So, it's so unbalanced, the system of justice that has been created by the attorneys. The lobbyists and the legislators that created this are all, association attorneys or developer attorneys, and they're not writing these CC&Rs to protect the homeowners. They're writing them to protect their own interests. We should have the right to an attorney general, an ombudsman for the homeowners. The Attorney General's office can charge an annual fee of $100 to $500 per association to fund the office's ombudsman, so that person can look at CC&Rs, can say, yes, the board is following and complying, or no, they are not complying in your opinion. It doesn't have to go to court. The reasons people can't afford to go to court is because to go to civil court, you have to be able to establish damages. How do you establish damages when you can't even get the records of the association? It's an unbalanced system, and we need to do something about it. I look at so many decisions made by boards and property managers and attorneys that are so unethical and wrong, and how they treat the homeowners, how they talk to the homeowners, email after email of just, making homeowners feel like they're not important, that their concerns are not being heard because they're speaking against the boards. We have a right to speak up. That is the fair speech applies to everything. Our, political opinions. We should be able to do those things in our own homes and to fight for our homes. Just as the board wants us to be responsible and to be held to the CC&Rs, so should everybody else. And I think that keeping everything fair and equal is what we should do, and a Bill of Rights is needed. This Bill of Rights that I've showed you online is just my opinion, but it is a start. Somebody has to think about protecting the homeowners because nobody else is doing it. So in my opinion, this is what we should do for Washington State and every other state. Let's protect our homes and our homeowners and keep people in their houses. Speaking up matters, and we should speak up. Tell your legislators you need a Bill of Rights. All right, I'll see you on the next one.